In estate planning, a living trust is a powerful tool that can help individuals manage their assets during their lifetime and facilitate the transfer of those assets upon death. This video will explore what a living trust is, how it differs from other types of trusts, its pros and cons, and whether you might need one. What is a living trust? A living trust, also known as an inter vivos trust, is a legal entity created during a person's lifetime to hold and manage their assets. The person who creates the trust, the grantor or settlor, transfers their assets into the trust and appoints a trustee to manage those assets for the benefit of the beneficiaries. The grantor can also serve as the trustee during their lifetime, retaining control over the assets. Living trusts can be revocable or irrevocable. 1. Revocable Living Trust. The grantor can alter or dissolve the trust at any time while they are alive. This flexibility makes it a popular choice for many people. 2. Irrevocable Living Trust. Once established, this type of trust cannot be changed or revoked without the consent of the beneficiaries. It often provides tax benefits and asset protection, but at the cost of relinquishing control over the assets. How living trusts differ from other types of trusts. Trusts can be categorized in various ways, including Testamentary Trusts, created through a will and activated upon the death of the grantor. Testamentary trusts differ significantly from living trusts, which are created during the grantor's lifetime. Special Needs Trusts, designed to provide for a beneficiary with disabilities without affecting their eligibility for government benefits. Charitable Trusts, set up to benefit a charitable organization while offering tax advantages to the grantor. The primary distinction between a living trust and these other types lies in timing and function. Living trusts are operational during the grantor's life, allowing for asset management and avoiding probate, while testamentary trusts come into effect only after death. Pros of a living trust. Number 1. Avoiding probate. One of the main advantages of a living trust is that it allows assets to bypass the probate process upon the grantor's death. This can save time and money, as probate can be lengthy and costly. Number 2. Privacy. Unlike a will, which becomes a public document once it enters probate, a living trust generally remains private. This privacy can protect the details of your estate from public scrutiny. Number 3. Flexibility and control. With a revocable living trust, the grantor maintains control over the assets and can make changes as circumstances evolve. This flexibility allows individuals to adapt to life changes, such as marriage, divorce, or the birth of children. Number 4. Disability planning. If the grantor becomes incapacitated, a living trust can ensure that assets are managed according to their wishes without the need for a court-appointed guardian or conservator. Number 5. Streamlined Distribution. A living trust can facilitate quicker distribution of assets to beneficiaries after death, as the assets are not tied up in probate. Cons of a living trust. Number 1. Initial setup costs. Establishing a living trust can be more expensive than creating a simple will. Legal fees for drafting the trust and transferring assets into it can add up. Number 2. Ongoing maintenance. While a revocable living trust can be adjusted, it requires ongoing maintenance, such as updating the trust to reflect changes in assets or life circumstances. Failure to do so can lead to assets not being distributed according to the grantor's wishes. Number 3. Complexity. Living trusts can be more complicated than wills. For some individuals, understanding the legal implications and proper administration of a trust can be challenging. Number 4. Limited asset protection. While living trusts help avoid probate, they do not provide significant asset protection from creditors. Creditors can still access assets held in a revocable living trust. Number 5. Tax implications. While living trusts typically do not affect taxes during the grantor's life, an irrevocable living trust may have specific tax implications that need to be considered. Do you need a living trust? Whether you need a living trust depends on several factors, including Number 1. Size of your estate. If your estate is large or includes complex assets, a living trust may be beneficial in avoiding probate and facilitating asset distribution. Number 2. Family dynamics. If you have a blended family or specific wishes regarding asset distribution, a living trust can help ensure your intentions are met. Number 3. Desire for privacy. If privacy is a concern, a living trust can help keep your estate matters confidential. Number 4. Concerns about incapacity. If you are worried about potential incapacity, a living trust provides a mechanism for managing your assets without court intervention. Number 5. Financial complexity. For those with investments, properties, or business interests, a living trust can offer a structured approach to managing and distributing these assets. A living trust can be a valuable tool for effective estate planning, offering benefits such as avoiding probate, maintaining privacy, and ensuring seamless asset management. However, it also comes with its own set of complexities and costs. Ultimately, the decision to create a living trust should be made in consultation with an estate planning attorney, who can help assess your specific needs and circumstances. By understanding the nuances of living trusts, you can make informed decisions that will safeguard your assets and fulfill your wishes for the future. Thanks for watching. Please subscribe.